Hello, everyone. I'm really pleased to have you here in this webinar called the Evolving Legal Framework for the Management and Governance of the Groundwater, Domestic and Transboundary. This is a webinar organized by the IUCN WCEL Water and Wetlands Law Specialist Group. Well, you know, the International Union for Conservation of Nature and STEAM, we are attached to the World Commission on Environmental Law. And my name is Michael Hankidomas, and I'm Deputy Chair of the IUCN WCEL Water and Wetlands Specialist Group and Associate Professor at the Law School of Universidad San Sebastián in Chile. I would like to give a special thanks to Roberto Cole from the WCEL Secretariat and Alejandra Bonom and Rocío Catalán, both from the Water and Wetlands Law Specialist Group Secretariat based at Universidad San Sebastián in Chile. So we are today discussing a central issue nowadays in terms of global governance. As groundwaters covers approximately 30% of planet's available fresh water. And it's the main source of drinking water for more than 2 billion people around the world. And this water is stored in the pores and crevices of rocks and soil and slowly recharged by snow and rain. So therefore, it's very sensible to overexploitation around the world. So you know that this groundwater, it's about 1,000 times more water than all the surface rivers and lakes. So we are talking about a large amount of fresh water for all humanity. And we are having, probably you've learned about this effect that water extraction from groundwater is producing around the world. So basically, this the amount of water abstraction around the world is moving the axis of the planet. So this is very interesting. Is the research being done in India and in America. So so the implications of water is not just related to human consumption, but as well to the whole planet in terms of physicalities and weather. So climate change is expressed particularly in the case of water. So despite of the importance of this matter, we are in a world where the rules on groundwater, domestic and international water courses, it's very feeble in terms that we don't have a treaty, an international treaty covering all this issue. We have several experiences around the world, and today we are really happy to host big names and big academics and associates on groundwater and law. So we are going to give the floor to 4 presentations. The first one is going to be given by Stefano Burchi, the second one by Barbara van Koppen, the third one by Gayathri Naik, and the last one is Gabriel Eckstein. So I will present each of one. So we are going to start with Stefano. Stefano Burchi is an Italian national and recognized specialist in the field of freshwater, domestic comparative law, and international transboundary law. And he happens to be the chair of the Water and Wetlands Specialist Group at IUCN and WCEL. He holds an LLB from La Sapienza University in Rome, Italy, and an LLM from Harvard Law School and MS degree from the University of Michigan in the USA. Mr. Burchi had a career in the service of the United Nations as a water law specialist advisor in the UN Secretariat in New York, USA, and in the Food and Agriculture Organization at the FAO in Rome, Italy, where he concluded his tenure as service chief. While at FAO, Mr. Burchi served as in-house legal expert and advisor on domestic and international water law to FAO member countries in Asia, Africa, and Latin America. Furthermore, Mr. Burchi advised various organizations on programs on on global and transboundary water issues, including UN International Law Commission, the UNESCO ISARM program, and the World Bank. Since retiring from FAO, Mr. Burchi has taken up a variety of water law consultancies with UNESCO, FAO, GEF, the EU, especially, and the government of Bhutan, El Salvador, Guatemala, Honduras, Nicaragua, in many places. And in addition, Mr. Burchi has authored numbers of publications on water resources law and administration, including FAO legislative studies number 52 and 80 on preparing national regulations for water resource management principles and practices. So you have here one of our foremost specialists, and we are so welcome to have you. Please, I will give you the floor, Stefano, please.
Thank you very much. Thank you, Mike. Good afternoon, one and all. Let me see. Okay. All right. Can you see?
Yes. Yes, we can. We can,
yes,
Stefano.
but unfortunately, there we are. Okay, this is the first slide. Well, good afternoon to everybody, and welcome to the webinar, also from my own personal end. I will zoom in on domestic legislation for groundwater management, or regarding or reflecting on, reverberating on groundwater management, conservation, protection, and use. And I will provide a comparative overview from a comparative law perspective. Now, in particular, since I mean, the scope of groundwater relevant legislation is quite wide and broad, so I have chosen to focus my attention in this presentation on what I consider to be emerging directions in the domestic legislation drawn from a selection of countries that I have studied and observed. And in particular, on the land groundwater interface, on the ecosystem support function of groundwater, and last but not least, on the human right to water, including groundwater, of course. Now, these to me are quite critical dimensions of the groundwater management spectrum, and they are particularly complex because they reach out to beyond groundwater, to beyond the groundwater box, to beyond just water or groundwater legislation, and reach out to non-water legislation, so other domains of the regulatory spectrum. Now, as regards the land, the complex land groundwater interface, there are now impacts that land uses and uses of the subsurface space have on groundwater, both groundwater quality, but also the natural processes whereby groundwater gets replenished through discharge, through recharge, but also through discharge to notably springs, wetlands, and oases. Now, these interactions, the interface between land and the subsurface space and groundwater is reverberating increasingly in domestic legislation of a number of countries, but also non-water legislation. And these reverberations can be seen in a number of approaches and mechanisms that address these very specific dimension of groundwater management. First comes to mind the restriction and the regulation of certain select heavily groundwater consuming practices, and notably, for instance, the paddy rice cultivation, which is regulated and restricted in a number of Indian jurisdictions. or the restriction and regulation of commercial forestry. And you have examples of this in South Australia. The years are those that, the relevant legislation dates back to, and South Africa, but also the coal seam gas extraction, for instance, in the Australian state of Queensland. These are all examples where of current legislation where you have this particular issue addressed and regulated. Another approach is factoring the impact on groundwater of land uses, including uses of the subsurface space. Now, for instance, this is a rather sophisticated approach that I'm going to mention. The Flemish region of Belgium it has a water law, a water act, but also a land use planning law that provide both mirror provisions that require a water assessment of land use permits, and that such water assessments be taken into account before a permit is granted. So you have a way there of a very cogent, compelling way of linking essentially the two domains, land use and groundwater, and the relevant regulations, the relevant legislation, and the relevant separate administrations. Now, similar mechanisms, not so sophisticated, but that aim at the same result of linking up, different strands of legislation and administration, you find in the laws, in the current water laws of countries like Tanzania and Zambia in Southern Africa. Another approach is zoning for the purpose of restricting land uses that are inimical to groundwater quality and groundwater recharge and discharge. For instance, in the Australian state of New South Wales, aquifer interfering activities on land and under the surface require a government permit and a management plan. But this is again quite a sophisticated approach. Now, zoning for groundwater, for specific groundwater protection purposes, features also in the water laws of Bhutan, Cuba, Ecuador, Kenya, Namibia, so contemporary water laws. So you see quite a spread of, of countries that have resorted to this particular mechanism to address the issue that I mentioned. Now, also pollution of groundwater from non-point or diffuse sources comes in the scope of this, of the land-groundwater interface. If you think in particular the runoff and drainage that comes from irrigated areas where pesticides, fertilizers, and animal manure are employed, this is another manifestation of this interface, and where the impact, in particular on groundwater quality, is dominant. In an urban environment, you have also stormwater runoff of polluted surfaces that come also in the picture and is relevant in this context. Now, non-point source pollution is addressed in the laws through the regulation of land and subsoil surface space uses, notably cultivation practices, like in the European Union Nitrates Directive of 1991, or landfills, waste dumps, and the underground storage of substances to minimize the risk of leaking to aquifers and polluting groundwater, and mining. Now, these regulations are mostly found in non-water laws. So coordination and consistency across the regulatory spectrum that impacts on groundwater is desirable, if not necessary. Now, regarding the ecosystem support function of groundwater, this is becoming, quite a concern and of relevance, as opposed to and distinct from the utilitarian function of groundwater. In other words, groundwater for consumptive uses, for the satisfaction of a number of needs, of water needs, economic and social. But the environment, and in particular environments like wetlands, oases, do have, do call for volumes of and appropriate quality of groundwater for their support. And this concern the groundwater, the ecosystem support function of groundwater reverberates in contemporary water laws in a number of ways. For instance, by mandating the survey of wetlands and oases and of groundwater that feeds them, that discharges to them. This is seen in a recent piece of legislation enacted by Niger in October last year, 2022. So it's very recent, a very compelling piece of legislation that squarely addresses this issue. Or another approach is restricting land and subsurface space uses that are inimical to the natural groundwater discharge processes to oases and wetlands. And we saw a number of examples in the previous slide. Or by setting aside groundwater volumes that are required to protect and support groundwater-dependent ecosystems. This is known as the ecological reserve, pioneered by South Africa's Water Act of 1998, that the next speaker in line, Barbara van Koppen, will zoom in on and illustrate. But it then picked up by the water laws, contemporary water laws of a number of countries, mostly from Central and Southern Africa. And you have various examples there. And also another instrument which is quite powerful and quite significant is empowering government to scale down existing extractions that imperil groundwater-dependent ecosystems. And you see that a good example of that in the Namibia Water Resources Management Act of 2013. This is quite an impactful instrument because it eats into existing water rights, groundwater extraction rights. Now, the other dimension that I want to bring in and zoom in on is the human right to water, and I put ground in brackets because for the satisfaction of the human right to water for basic human needs, groundwater plays a very important, if not dominant role. And that's why I think it is quite appropriate to look at this dimension and bring in this dimension in the scope of these emerging directions of water legislation. Now, the water laws reflect this, the human right to water, appropriate, if you like, the human right to water through a number of, essentially by positing, capturing the human right to water as a matter of policy and principle, and sometimes, but not always, also operationalizing that right. And this operationalization, the realization, if you like, of the human right to water is achieved in the water laws, in the contemporary water laws that posit the human right to water as a matter of policy and principle in a number of ways and through a variety of means. By prioritizing domestic water allocations, and you see examples there. Another cogent example will be illustrated by Barbara van Koppen right after me, drawn from South Africa. Or by directing government to guarantee access to unpolluted water for basic human needs. Or by directing government to set aside quality water for the satisfaction of basic human needs within certain quantitative limits, subject to respect for equality, non-discrimination, and gender standards, as in the case of Ecuador. And there you have different examples. Now, I'll stop here, but before I draw my conclusions, I would like just to quickly mention that what you find in the water laws, these mechanisms and instruments are well and fine on paper, but then the critical, very often neglected, dimension of the water law cum governance spectrum is the implementation and enforcement of legislation. Now, the observation and experience shows that a number of factors contribute to the effectiveness on the ground of groundwater regulation in general, including the regulation that addresses those particular aspects and those particular issues that I mentioned and I illustrated in my presentation. One is a sensitization and uptake by the target groundwater user population. Another one is the preparedness of the government water and groundwater administration to live up to the challenge of, the legislation. Effective self-monitoring of groundwater user behavior, self-monitoring by the groundwater users themselves. You can't have a policeman at each and every well, in other words. And the effective pursuit of offenses by an environmentally educated police force and judiciary working together, working in coordination. There is anecdotal evidence, an example, all of this that I have very quickly described. Now, coming now to the conclusions. Based on my observation, there is a trend, a discernible trend in the contemporary water laws to capture the land-groundwater interface at various points of intersection and interaction, to account for and protect the ecosystem support function of groundwater, in particular in relation to oases and wetlands, and to acknowledge and try to operationalize the human right to water and groundwater in particular for basic human needs. And these emerging directions that I illustrated bear out, to my mind, the awareness of lawmakers of the importance of reaching out to beyond the groundwater box, but also the complexity of ensuring coordination and consistency across different strands of the regulatory spectrum that affects and impacts on groundwater. Well, thank you for your attention. I'll stop here and turn the floor to our moderator.
Thank you, Stefano. You were spot on time. So thank you for that. And now we are going to have another splendid presentation by Barbara van Koppen. And she's going to talk to us about the approaches and experiences of South Africa, which is a wonderful experience in the country. So Barbara van Koppen, she's a PhD and is a principal researcher on poverty, gender, and water in the International Water Management Institute based in the IWMI Southern Africa office in Pretoria, in South Africa. She leads multi-country research in Africa and Asia on legal pluralism, water law, and community-driven water service delivery from a gender and human rights perspectives. So she's the lead author and editor of 5 books and co-author of over 120 international peer-reviewed publications. She engaged in national and international policy dialogue, among other, as coordinator of the Global Multiple Use Water Services MIUS group. She served in the steering committee of the GWP Global Water Partnership. So Barbara, thank you for being with us, and yours is the floor.
Well, thank you for the invitation, and thanks Stefano as well for putting the basis for what I'm now going to elaborate specifically for South Africa, which is known, I guess, for an innovative National Water Act at the end of apartheid, where an ecological reserve has been established as one of the first. This is implemented, in any case, defined quantitatively for service flows. For groundwater as such, it's still under consideration. And in my presentation, I'm not going to talk about the evident water quality issues, but really focus on the water quantities and raise a thorny issue. Because for human uses, you can't avoid taking water out of the groundwater, the natural resource service or groundwater. So there is it means that the moment we agree, okay, there should be water, 1/3 should stay in the flows, it means that the competition for the water that is taken out increases, which makes what I'm going to present, how to meet the human rights, or in South Africa, the constitutional rights to water and food, how to reach that becomes, on the one hand, becomes difficult. And South Africa has been struggling with that, as I'm going to explain, but came up with a legally binding prioritization for all water sources. And I think I will elaborate it more for surface water, but water is water. It is interconnected. Wetlands are interconnected. Managed aquifer recharge uses that interconnectedness. And I would even see that it is a general value that holds at local, but even at national state, and it can even operationalize transboundary notions like reasonable use, no harm, etc. And most importantly, it holds, everybody can understand prioritization, whether you speak English or not, or whether you have a degree. And that's, of course, very important for any implementation. Briefly, the reason for South Africa to put this on the agenda are the huge inequalities in access to water for human use, related to a history where the whites dispossessed Africans of 87% of the land and water. And we did some research that of enormous Gini coefficients, 2% of the people using 95% of water, even for registered users. So the people who have already been formalized to some extent, the 7 largest users, they use 84% of the total volume of water used. And if you are even going to add the small, tiny users, you still hardly have any volume, as you see in the picture. So the statutory provisions, probably known, the Constitution, right to water and food, of course, racial equity, and that was then operationalized in the Water Act. Important thing, the government declared itself as public trustee of all water resources. So the apartheid era private groundwater titles on own land were abolished. The goals of the National Water Act are very clear: equitable access, redressing inequities from the past. And then the huge issue of how to convert apartheid era racist water law into the new democratic state supported water law means literally that under some circumstances, the existing lawful uses of the past can be expropriated without compensation, if need be. And then, of course, as you mentioned, Stefano, then implementation is next, is learning by doing, and realizing that the main tool, which is a permit or a license, in South Africa it's called a license, that's for post-1998 new water uptake. They realize that even for new water uptake after 98, it's not working. And especially excluding many South Africans who are not formalized, who don't speak English necessarily. And basically, as you see in the 2 triangles, the large majority, millions of people who just get water for basic human needs, or maybe a little bit more with farmer-led irrigation development, self-supply, they can get a little bit more well-being. All those people, you can't reach them with licensing. And that then gave the idea we have to separate between the few big users that need to be regulated, and we have to find other tools to at least avoid that they are discriminated administratively, or that we say, no, you are exempted from licensing, and that means that you become invisible. So we got this idea of hybrid law. And the tool in the National Water Resource Strategy is then by prioritization. So whatever the competition, let us declare the winners and the losers, because that will protect the people who otherwise would lose. So the highest priority for the reserve, both the ecological reserve and the basic human needs reserve. Then second, international requirements. I'm not going to talk about that. And the third priority is very interesting because it operationalizes the goals of poverty eradication, livelihoods, and greater racial gender equity. And that is a higher priority than even than the electric power cooling plants, which are called strategic uses. And it has a higher priority than even the general economic purposes. So whenever a large-scale farmer and a small farmer are together fighting for the same groundwater resources, the small-scale user can say, sorry, it is poverty eradication, I have a higher priority than you. And then quickly through the three most important one about human uses. Interestingly, the reserve, the basic human needs reserve, was at the time set at 25 liters per person per day, but that was for the infrastructure. And when we talk about water, we talk about infrastructure and the resources that flow into the infrastructure. So 25 liters was a very important and good step for the first commitment of government to make sure there is infrastructure for nearby, affordable, safe water for drinking and domestic uses. But when we think only about the resources, the groundwater or the surface water resources, we talk about many other uses that meet constitutional or human rights, as you say, Stefano, human rights, constitutional rights as well. And there the debate comes up, all people who are now exempted from the obligation to apply for a license, can't they have a priority, as already happens in some countries, but not in South Africa as yet. Another point about the ecological reserve, it's painful in the sense that in South Africa, it used to be environment is wild parks, is Kruger Park, or St. Lucia. It was only later that they say, no, in the ecological reserve is for the whole main stem of the river or for groundwater. But still, this notion that environment is a wild park is still very strong. And we still see that, yeah, the tourist in Kruger Park, I can invite you, it's gorgeous, but that then wants to have pristine water for the giraffes and the lions and the tourists. But upstream, there is a former homeland that doesn't even have water for domestic uses. So these are issues to further unpack. The poverty eradication issue, it gets into the whole debate of the recognition of customary water tenure into the former homelands. A hugely important issue in Latin America already, and in Africa, where 60% of land is customarily governed. And it's a huge issue. Where I think it is useful to distinguish between the sharing within the boundaries of a clear, local, informal setting in which people have managed the water resources since time immemorial. So the local norms that already look at being careful about groundwater, tapping into groundwater, that can be mobilized in the sharing in. But when we are talking about the stream that comes through, it comes from the formal economy, moves into the former homelands and then moves out again, that should have a priority according to the prioritization rules of the National Water Resource Strategy. And lastly, there will be a gray area now between the evening customary areas, but nationwide, between the small-scale black users who are really water for life, it's clear, but also the ones that are medium scale, etc., but still don't speak English or don't have the access to the water authorities. And can't we have a license application procedures that are more equitable and proportionate to the use. That's another debate. And then lastly, it's two sides of the same coin. If you give a priority to one, it means that the other has to minimize, which doesn't happen in South Africa at the moment. Even for the new uptake, water uptake after 98, it's again, large majority are the historically advantaged individuals, basically white or black middle class. Compulsory licensing hasn't really been worked. And basically, and I will conclude with the court cases, that the organized white farmers are even contesting the power of the states as public trustee. And that's how they do that, to conclude. In trying to curtail the continuing water uptake of let me call it quickly, white farmers, the department said, if you can trade, because that was blossoming, if you can trade water for money, so not the water infrastructure, but the entitlement to water, if you can trade that to somebody else, it means you don't need it. And our rule is use it or lose it. If you don't use, you lose it. But then the white farmers organized, went to the High Court and said, no. But the High Court said, no, we agree with the Department of Agriculture, water, of course. The trade is not allowed in South Africa because a large majority of people can't afford, and it would aggravate the injustices. It's a huge point, of course, for all debates, also in Chile, etc., on the trade, monetary, the commodification of entitlements, whether surface water or groundwater. Then the white farmers in 2021, they went to the Supreme Court of Appeal, and there they won the case. And the argument was again, yeah, but if it isn't taken up by somebody else, the water goes to waste. Ignoring that there is competition for water in most places of South Africa, and there is the ecological reserve that is hardly implemented, I must admit. The one judge didn't agree, and he really raised the point. I fill a form, then I give it, and I get the stamp of government, and suddenly that form has a value of really hundreds of thousands of dollars. And then last year, the department went up to the highest court, Constitutional Court, and said that what is happening. And then the judge had to say, well, there is a legal loophole, section 25.2 can be interpreted that the entitlements, especially existing lawful uses, not licenses anymore, existing lawful uses from the apartheid era, you can interpret it as if it is a right to transfer as well. So not only a right to use, but even a right to transfer that entitlement. So now, but it was a clear statement of the Constitutional Court. This is not the spirit of the Act. And now the government is amending the Act. So some highlights on who gets the scarce waters.
Barbara, we are time. Oh, wonderful. Fantastic. Thank you very much. You are on time as Stefano. You're wonderful. So thank you for that presentation. Very interesting. And certainly we're going to have a lot of questions about that. And now we are hosting Gayathri Naik. Gayathri is an assistant professor of law at the National Law School of India University. Previously, she was assistant professor at the National Law University in New Delhi, where she also coordinated the NLUD SOAS, University of London, Summer School on Climate Law and Justice, supported by the British Council Explanatory Grant. She has also worked as a graduate teaching assistant in SOS. Gayathri holds an LLB degree from Mahatma Gandhi University, Kottayam, an LLM in International Legal Studies from South Asia University, New Delhi, and MA in Public Administration from the Indira Gandhi National Open University, and the PhD in Environmental Law from SOAS University of London. Oh, she's a member of our specialist group of the IUCN WCEL in the International Union of Conservation of Nature and the World Commission on Environmental Law. She belongs to our group, the Water and Wetlands Specialist Group, and now she's invited as well on her capacity as Early Career Specialist Group member. She's also a member of the Compliance and Enforcement Group, as well as the Law, Environment and Development Center at SOAS in London. She's also an editor on transboundary water issues with the Global Water Forum. She has published articles and books, chapters on various dimensions of water law in journals and books published by OUP, Brill, Routledge, and Edward Elgar. She was also presenting her work at different institutions, including Vermont Law School, UCL, KCL, and Sussex University in the UK. So, Gayathri, welcome, and the floor is yours.
Thank you, Michael. I hope you can see my screen.
Yes.
Yes, we can.
Thank you. Okay, thank you.
You have to project your slide. There you are.
Okay.
Wonderful.
Yeah. Okay. Thank you. So, what I will be focusing is the approaches and experiences of India in groundwater use and regulation. So, the structure of my presentation will include these following aspects, right from the magnitude of lands and groundwater, the challenges which we are experiencing in India, what are the regulatory framework, including the land or the common law framework plus statutes. Are there any inequity or injustices faced in the current regulatory framework? Why we need a revamping in the current framework, and what will be the possible solutions which we could impart. So, starting with the groundwater reliance in India, India is the largest user and exploitation of groundwater in the world, because the primary, so it supports the primary requirements of the Indian population in case of drinking water needs and the irrigation water demands. You can see from the slide, almost like 62% of the total irrigated areas, 85% of the rural drinking water supply, and in case of urban drinking water, 50% of the water requirements are satisfied by the groundwater resources. Basically, the groundwater issues in India evolved from this basic fact that it supports the total irrigated water demands of the country, as well as the support to the rural drinking water supply, because most of the water supply schemes in the country are targeting the rural areas, and most of them are groundwater dependent schemes. So, as I said, India is the largest user and exploiter of groundwater resources in the world. So why it has turned to be the most groundwater user as well as exploiter? So there are a lot of factors which are interlinked: the technical, financial, policy, and regulatory framework, which constitutes the dependence of groundwater and leading to its exploration and then to exploitation. One of the primary resources for depending groundwater in most of the parts of the country is because of its easy accessibility. I mean, the hydrological situation, because, for example, in case of irrigation, the groundwater is preferred to surface water because the landowner or the agriculturalist need not wait for the whims and fancies of the state-supplied canal water, the laggings of water availability in the state-supported water system. So instead, he can always rely on the groundwater, which is easily available in his land or through his neighbor's hand for catering to the irrigation water demands. Like I said, there are several factors like technical, financial, policy, and regulatory. Not all these factors can be isolated. All these are interlinked. When I say technical, it includes the mechanized pumps, availability of the mechanized pumps, the energy improvements, because earlier, for example, in irrigation, there were diesel pumps. Now there are electricity run, or there are motor pumps which are run through the help of electricity. So these technical developments have helped the farmers to rely more on groundwater for irrigation. The financial, there is a credit flow from private and public resources. When I say public, it's from the formal resources like banks. When I say private, there can be two instances, like the fieldwork experiences in Gujarat and Rajasthan, for instance. They help us to understand one private sources. For instance, what happens in the irrigation sector or the agriculture sector is that one member of the farming family will go abroad and work and earn, and those earning member will be supplying the financial credit, or he will be investing in the irrigation water demands, especially in the groundwater pumps, which has led to the influx of informal groundwater markets in water problem areas in Rajasthan as well as Gujarat. When I say policy factors, they're basically the subsidy elements which are given by the government for energy, credit, input, as well as output. Among these subsidies, as a policy instrument, energy subsidies has created a huge problem to the groundwater situation in India, leading to the situation where groundwater is now overexploited in most of the agriculture-dependent states like Punjab, Rajasthan, Haryana, and Uttar Pradesh, to name a few. Another important and the most important factor for groundwater exploitation and widening the course of groundwater exploitation is the current regulatory framework, which is the land-water nexus, on which I will be focusing on right now, which has led to the overexploitation in different areas. What is the regulatory framework? We shall see in the subsequent slides. So I've just given an overview of the situation in India. It's sourced from the Central Groundwater Board, and the data is from 2022. So coming on to the regulatory framework, in India, the regulatory framework governing groundwater is pluralistic. Basically, the access and allocation of groundwater resources is governed by common law principles of land-water nexus, where groundwater is considered as a chattel attached to land, which means the landowner has the right over all the water resources beneath his land, and he has the absolute right to use as much water as he requires. So there is no remedy available for his neighbor if he extracts as much water as he requires, and consequent loss to his own water resources. So this land-water nexus has become the most important and complex issues in the country for groundwater regulation, and it has been the cause for most inequities and injustices, which includes both social as well as environmental. When I say it is pluralistic, another important factor is the environmental law statutes and principles and judicial decisions. Basically, the judicial decisions in addressing the issues of water pollution, groundwater pollution, the judiciary has relied on this environmental law statutes and principles like Environmental Law, Environmental Protection Act 1986, and the principles like precautionary and polluter pays principles. And there are certain water law statutes also trying to regulate the groundwater extraction and exploitation. So when I say it's a common law principles of land, many scholars have said there are elements reflected in the Indian Easement Act of 1882, which discusses about the landowner's right over water resources. But over and above, if you analyze this Indian Easement Act 1882, we cannot categorize groundwater as an easement, but groundwater should be considered as a chattel attached to land. Land-water nexus, which has become it has been an inequitable framework. It has led to the overexploitation of groundwater resources and led to its deterioration, including the quality of its resources. By this nexus, there's an interconnection between overlying land and the underground water resources, granting the landowner absolute right over the water resources. If you trace the history of the development of this land-water nexus, which is currently followed in India, we can see that has been developed in the common law, and that has been implanted by the British people in the then British era in the Indian subcontinent, even though that never fitted to the social, ecological, and hydrogeological situations of the Indian subcontinent. The courts in India have applied these principles even since the British era. If you can see the remnants of the application of these principles, including one of the controversial case of a Coca-Cola company extracting groundwater resources in a small hamlet, at a tribal hamlet in one of the districts in Kerala, which came to be known as the Plachumada case. So when I say inequitable, it includes both from sociologically and ecologically, how it constitutes sociological or social ecology, social inequity. The land-water nexus basically confines the water access to landowners. The social situation, the economic situation in their country, especially with the land ownership, has always been influenced by the social factors like caste, gender, and economic situation. Land ownership has always been skewed to the caste and gender, where the higher caste own more land, and also women do not own as much land like their male counterparts. The social and economically deprived communities like Dalits also face this inequity and injustice in accessing groundwater for drinking as well as irrigation water uses. Then because of this, another factor which influences the access to groundwater and has created inequity is the pollution and purity factor, which means that the untouchability has always been there, and it also prevails in certain parts of the country. There are news from different parts of the country where the Dalits are deprived of accessing water resources like wells, because the community feels that once they access this water resources, the water resource gets polluted, and there's a purity factor. So that's called the pollution and purity factor in accessing water resources. And there is also inequity in access to social and economic factors, especially access to government aid like subsidies, credit, and technology, which I myself have seen through my fieldwork during the PhD thesis writing. Because when we say that land-water nexus has influenced the water access and allocation, this land ownership has also influenced access to subsidies in the form of energy or credit or technology, whatever. These policy instruments also have an influence of these property rights, which in turn is influenced by the social and economic factors like caste, gender, and economic relations. Another factor which gets attention is about the ecological and water sustainability. We have the issues of groundwater pollution, including exploitation, pollution, and degradation. When we say it is inequitable, like I said, social inequity is prevalent, with the poor and downtrodden sections being denied access to clean and safe drinking water. And they are the ones who contribute less to the ecological unsustainability. So there has been always an inequitable benefit and burden sharing in water access and allocation, which has compromised the intergenerational as well as intergenerational equity. And coming on to the drinking water resources or drinking water applicability or reliance on the groundwater resources, the government has focused on the supply sustainability of all the water supply schemes, most of which are groundwater dependent. Most of the schemes have less focus on ensuring the source sustainability, that means protecting the groundwater and the aquifer as such. Irrigation, especially the agricultural water use, has led to the water pollution, groundwater pollution, which has not yet received adequate attention in the policy discourses as well as legal discourses, because the pollution aspects in the country has always revolved around the pollution caused by the industrial activities. It's yet to receive much attention on the agricultural pollution, because agriculture, the support of agriculture to the economy is too huge. But now it's high time that the ecological and water sustainability issues caused through this pollution aspects should also receive much more attention. When I say the question about attempts to regulate, There has always been attempts to regulate this groundwater extraction, exploitation, and the pollution. But the land water nexus, which regulates the access and allocation of groundwater, still continues. Neither the legislature nor the executive have attempted to change the status quo. There are attempts to regulate groundwater exploitation through piecemeal approaches. Say, for instance, the model bills were circulated by the central government. Why I stress on the model bills by the central government is because the constitutional framework of division of powers grants the state governments or the provinces as such the exclusive right to enact laws on water, except on the interstate water rivers, which is under the domain of the central government. Even though that is there, the central government, considering the importance of groundwater and the negative externalities of policies like Green Revolution, have tried to bring some regulation in the form of circulating model bills to the state government to make them or to inspire them to enact laws. But these legislations in the form of 1970, 1992, and 2005 model bills have grandfathered the existing regulation that never talks about the land-water nexus. No attempts to change the groundwater land-water nexus there. It has overruled the constitutional division of powers because it's the central government that has circulated. But there are states which have enacted the model legislations based on this model bills like Kerala, Tamil Nadu, and all. But the most groundwater dependent states like Punjab and Rajasthan are yet to make a law that regulates the groundwater exploitation. There's a lack of precautionary approach in this legislation, which has already been there. The common mode is the command and control approach. And more focus is provided on the anthropocentric water use rather than the ecological sustainability or ecological water resource. And the most important and the gravest issue of this groundwater law is that they are not fit for the local situations, because most of the times, if you talk to the hydrogeologists across the country, they are not satisfied with the implementation of this law, because this law caters to the groundwater situation or the groundwater problems of the North Indian states. But since the situation of the other parts of the country being different, there is no provision for customizing the principles which are required to address the local situations in other parts of the country. It's like a framework legislation, but lacks the options for customizing.
Yeah, so we are on time.
Yes, sure. Okay. I'll just conclude. Yeah. So just 2 minutes. Since the groundwater supports drinking water and irrigation water demands, and this right to water as considered what is recognized as a fundamental right by the Supreme Court, the state has the duty to ensure that everyone receives access to clean and safe drinking water, and also ensure water for food in case of irrigation. So since the current regulation is socially inequitable and environmentally sustainable, the government has tried to bring up some legislative measures in the form of draft bills, like the latest one, Model Groundwater Sustainable Management Act 2016, which has moved from this land water nexus to say that the state will be the trustee of groundwater resources, and management of groundwater will be as a common pool resource under the concept of common heritage. But in this also, I suggest the local situation and the local problems have to be highlighted, and there should be an option for the state government or the local panchayats to customize the local needs and to address the local problems. Unless and until we have this community-led groundwater management plans incorporated in the current legislations, it's not going to work out. Thank you.
Thank you, Gayathri, and sorry about this. Okay, so thank you for your presentation, a thorough presentation about the situation in India, which is sometimes bleak, but we're going to discuss this further. So we are now hosting, well, our last speaker. He's Gabriel Eckstein. Okay. Gabriel is a professor of law at Texas A&M University School of Law, where he teaches courses on US and international water, environmental and natural resources law. Prior to joining Texas A&M University, Professor Eckstein held the George W. McCluskey Chair in Water Law at Texas Tech University, where he also directed the Texas Tech University Center for Water Law and Policy. Before that, he served as senior counsel for CropLife America, an agrichemical trade association working on environmental regulation and legislative matters, and as a litigator in private practice working on environmental toxic tort and asbestos case. Professor Eckstein has served as an expert advisor and consultant on US and international environmental and water issues to various organizations and programs, including the Geneva Initiative, the UN Educational, Scientific, and Cultural Organizations International Hydrological Program, UNESCO IHP, the UN International Law Commission, the United Nations Environmental Program, the UN Food and Agriculture Organization, the US Agency for International Development, the World Commission on Dams, the Organization of American States, the UNESCO OAS ISARM Americas Program, and various local water entities in the US. Currently, Professor Eckstein also serves as director of the international-based International Water Law Project and is principal of the international consultancy International H2O Solutions. He also is the current president and former treasurer of the International Water Resource Association, serves on the executive council of the International Association for Water Law, is an associate editor of the journal Real Research Perspectives in International Water Law, and is member of the editorial board of the Journal of Water Law. Finally, Professor Eckstein holds an LLM and JD degrees from American universities in Washington College of Law, an MS in International Affairs from Florida State University, and a Bachelor of Science in Geology from Kent University State. Well, we have here as well another impressive presenter, and he's going to give us a talk on the governance of transboundary aquifers, the emerging legal framework. So thank you for accepting our invitation, and the floor is yours, Gabriel.
Thank you so much, and hopefully you can hear me and see my slides now.
We can do both.
Great. So thank you, first of all, to IUCN for putting this all together, and Michael for moderating the program, and thank you to my colleagues for these really fascinating presentations. Up to now, you had pretty in-depth discussions of domestic groundwater legal regimes, and I'm going to take this to the international, so to sort of give you a different perspective in terms of how groundwater is regulated at this international or transboundary level. So I'm going to talk briefly about the relevance of groundwater, which we've already heard a lot about, challenges to developing international law for these transboundary groundwater resources, and then the trends that are emerging in international law. And then finally, I'm going to kind of maybe just highlight a few gaps that that remain in the law. Real briefly, we've already talked quite a bit about the fact that groundwater is so critical for all aspects of society. It is the most extracted natural resource in the world. Virtually every country in the world uses groundwater for some aspect of their society. We just had a really fascinating presentation on India, and you can see India is the global leader in groundwater extraction, which is a pretty significant development from, say, 30, 40, 50 years ago, when we really only relied or primarily relied on surface water resources. Groundwater has really taken a life of its own, so to speak, in the sense of becoming so critical for countries, for meeting countries' needs. And where this has become particularly, at least interesting for me, but also controversial in some cases, is in the realm of transboundary. And what I mean by this is where you have an international political boundary between two jurisdictions, state A and state B, and it just cuts right into the aquifer or right into the groundwater flows. And of course, we know the groundwater, any water, doesn't respect political demarcations. And we have to come up with some mechanism to deal with this. To address who owns it, who has rights to it, how much can you take on one side of the border versus the other side. So when we talk about international law, we're really talking about, whether it's customary international law or treaty law. And so this is a map showing you the latest knowledge, I think it's from 2021, of where all these transboundary aquifers are around the world. And in fact, we know that there's more than 468, and I say more than this number because we're still learning. We're still identifying new aquifers. And you can see in some places on borders, these lines are not very well defined. They're just kind of these blobs on the border. And we're still researching this. And I easily expect that this number could be, 1.5, 2 times larger than the current number that we see here. But with this in mind, can you imagine how many countries have actually entered into an agreement over this shared water resource? We know that there are over 310 transboundary water courses, rivers and lakes, and those we can see. I don't have that on the map now, but for those 310 plus international water courses, there's over 3,600 treaties. In fact, I think it's closer to 4,000 treaties now that govern things like navigation and allocation and rights to surface water, to rivers and lakes. So how many for transboundary aquifers? Well, comparatively, very, very few. That's about it. We have 7 formal agreements and 8 what I call informal arrangements. Formal agreements are ones that are binding on the governments. Informal arrangements are one that are voluntary, so non-binding. And speaking of non-binding, we also have 2 what we call global arrangements, non-binding guidelines or models that provide guidance in terms of groundwater regulations, but they're not binding, they're not authoritative, they're advisory only. And so we have to ask the questions, why is it that we've had so much difficulty in addressing these transboundary water challenges? And we can point to things like, lack of data, lack of information, climate change, of course, complicates the situation, but also the fact that you can't see groundwater. It's somewhere underneath the ground. You don't know exactly what it looks like. It creates a lot of problems in terms of trying to come up with a regulatory system that works across all sorts of different types of aquifers. And in fact, we have different types of aquifers that are transboundary, some of which are connected to surface waters and others that have no hydrologic connection to surface water. And again, we have to question what law could apply to all of these scenarios across these borders. Does it matter that the river forms the border and is connected to the subsurface aquifer, or does it matter that there is no river connected to the aquifer? Do you have the same rules? What about a fossil aquifer? An aquifer that has no natural recharge. So meaning that every time you take water out, you're depleting the resource. Should that be governed by the same rule or different rules? So these are just some of the challenges to conceptualizing laws at the international level. And as I said, to date, we have more than 3,600, as I said, I think it's closer to 4,000 binding treaties for water courses, surface water, and only just a small handful for transboundary aquifers, which creates a situation where we don't have much to go on. We don't have a lot of experience with transboundary aquifers and groundwater at the international level to really identify what law actually applies. Yes, there's treaties between a few countries. For example, Jordan and Saudi Arabia, but that law would only apply between those 2 countries. And because there's so few countries that have formal agreements, I can put them all on one screen. These are the ones that have some kind of formal agreement between them. And this next list is the ones that have, I mentioned, the informal arrangements that are non-binding. And then there's the the binding conventions that reference transboundary groundwater, but these are actually, they reference them in indirect way, to the point where I have to say that groundwater is really a secondary or tertiary priority, and we question the direct relevance of the law presented in these rules, in these treaties to transboundary aquifers. And then earlier I mentioned these global guidelines. Now, where does this leave us in terms of the law, the international law for transboundary aquifers? It leaves us with a lot of questions. Who really owns these aquifers that are transboundary? Is it state A or state B? Or is it both of them? If they both own it, in what kind of relationship? How do you regulate this fluidic resource that crosses an international political boundary? What obligations do the neighbors have to each other in terms of sharing the resource or protecting the resource, whether from pollution or depletion? What about exchanging data and information? At this point, all we can say is that based on the 7 formal agreements, 8 informal arrangements, a couple of global guidelines, all we can really say is that we have trends. And these trends are not absolute, they're not definitive, but they're trends suggesting the development, the evolution of customary international law. I put this one on the screen here is because exchange of data and information actually appears in virtually every one of these formal agreements and informal arrangements. And I used just the language from the draft articles on transboundary aquifers just to give you a flavor of what this means. But the countries seem to agree that they are obligated to exchange data and information on the status of their shared groundwater resource, and from geological, hydrogeological, meteorological, ecological perspective, and so on. So this is one of the trends that we're seeing appearing in the vast majority of these instruments. Monitoring also seems to be a trend. The idea that these countries that share this resource, they have to continue not only exchanging information, but developing new information, monitoring, so that they can learn how the system, the groundwater system, might be changing or reacting to depletion, to extraction, to pollution, depletion, and so on. 2 other trends that we're seeing amongst these various instruments. One is prior notification of planned measures, the idea that you have to notify your neighbor before you take any action that may affect the shared aquifer or have an impact on the other side of the border. And to me, rather surprisingly, the majority of these arrangements and agreements have some provision for a institutional mechanism to implement all these points of agreement that these countries have entered into in these agreements and arrangements. Now, if you'll notice, these 4 provisions that I put on the screen, they're all what I would call procedural measures. What is missing is substantive measures. Now, general obligation to cooperate arguably could be a substantive or a procedural obligation under international law. So I'm not quite sure that one fits the my conclusion that we're missing substantive provisions, but cooperation is somewhere in between there, in the sense that you have to have cooperation to share data information. You have to have cooperation to monitor and establish joint institutions and so on. Is it also a substantive obligation? I'm going to leave that for another day. But the point is, if it is a substantive obligation, it's the only one that we're seeing a trend, because we are not seeing any trends in these agreements and arrangements that suggest actual rights to the aquifer, and rights that will then create liability or responsibility for a violation of those rights. In surface water, we have equitable and reasonable utilization. We have no significant harm. These principles are do not consistently appear in all of these international instruments, the agreements and arrangements that I mentioned previously. So where does it leave us? It leaves us with a lot of gaps because we really aren't sure yet whether countries have sovereignty over their groundwater resources, or is it maybe a shared sovereignty with their neighbor, or maybe there's no sovereignty. We are not sure yet whether when you manage the resource, are you managing the groundwater or are you managing the container, the aquifer? And what about its functioning? You know, the container that provides the water space to flow through, that's a function, but it also functions as a filter for the water. It also functions as a storage mechanism. It also functions for a host of other things that we don't necessarily think about, even for example, as water for ecosystems, whether we talk about oases in the middle of the desert or actual habitats that exist inside of the aquifer. There are various aquifers where we have species that reside inside the matrix of the formation. And so these are the different kinds of questions that are still unanswered under international law. We really don't see any kind of trends amongst all of the agreements and arrangements that are in place to date. But I will say, let's wait and see, because many of these, quite a number of these agreements and arrangements have only appeared in the last 10 years, 10 or 15 years. These are new developments. And so there is movement in these trends, and the hope is that we will continue to see more countries entering in some kind of agreement or arrangements with their neighbors, and we will learn more about the extent to which countries are now developing customary international practices that lead to actual law. So thank you.
Well, thank you, Gabriel. Very interesting presentation about what is happening at international levels, and all the questions that still are present in our discussions in the case of the law. So now we are having just a few minutes, 10 minutes or 12 minutes for questions. And I would like to pose a question for all of you regarding climate change. So on top of all the problems that you are facing in domestic and international level, the whole hydrological cycle is getting faster. So so it means that probably we are going to see, well, we are seeing very heavy droughts. So Gayathri in India they are expecting to have a lot of problems with that, and we're having this in Latin America and Africa elsewhere. So how the law is going to cope with that challenge in terms of either mitigation or other strategies. So, for example, the case of replenishment of aquifers. So what are the solutions for those problems that we're facing on top of what you have been sharing with us? So, Stefano, do you have a view on this?
Well, there's no doubt that the groundwater is increasingly regarded too as a strategic, it has increasingly a strategic value, strategic importance to offset, or at least to mitigate, the effects of, this changing climate, particularly with respect to the availability, so volumes, quantities of water and the formation of groundwater. So a number of things, a number of instruments and approaches that I illustrated surely can work in that direction of, how would I say, protecting groundwater, but protecting the groundwater from, in particular, heavy human interference from not only overexploitation, but also, interference with these natural processes whereby groundwater gets recharged naturally, and also groundwater discharges to springs or systems like wetlands and oases. So to my mind, there is no, there is nothing, I would say, we don't need to reinvent the wheel, in other words. There is no need, to my mind, to reinvent the wheel, because the mechanisms are there. And I think it's just probably a matter of making more consistent use of them through a serious concerted effort at implementing and enforcing what's already there, with a view to, and with particular, mind to, offsetting and mitigating the effects of climate change, and enhancing and recognizing the strategic value of groundwater in doing that. This is valid also for at the transboundary level, which it's a totally different kettle of fish, but also, the same problems arise in that particular context.
Okay, thank you for that answer. Barbara, do you have a view on this?
Yeah, largely, thank you. Largely agreeing with you, Stefano, that, well, and let me even say it more bluntly, there is nothing new in the terms of climate variability, extreme events, and the way in which we have to deal with that. But what I do see is that the importance of storage when there is too much water for the period, the droughts, the dry seasons, dry spells, when there is not enough. So with the recognition of climate change, the variability is getting stronger on the agendas. And with that, also the managed aquifer recharge. India has done so much on that as well. So how can humankind support the recharge? But and lastly, it really is important then to listen to the way in which rural communities have managed, know about the resource and have managed their water resources since long. So I see changing emphasis, but the water management remains water management. Yeah, thanks.
Thank you for that answer, Barbara. Gayathri, do you have any views on this, especially in India?
Yes. See, from the Indian perspective, of course, we don't have a climate law as such, but there is a national action plan on climate change in 2008, which has 8 submissions, and one of the submissions includes a national mission on water. But even though, that's only a policy instrument, it can bring a little bit change, but unless, for instance, the groundwater, the most affected resource or one of the most challenging resource for climate change impacts, in order to address the climate change impacts, what my suggestion and my observation is that first we should move beyond this regulatory framework, which is currently under the private access and allocation mechanisms. It's not only the law which can make change, but also there should be a perception from the people's side about the recognition of the conservation of water resources. For instance, I'll just give you an example from the Rajasthan ground situation. Rajasthan is one of the most driest areas in the country. And one of the most groundwater dependent country. There is a lot of conservation activities conducted from the side of the government, as well as different NGOs are also working. But when we talk to the people at the ground level, the perception of the people or how they conceive conservation is that conservation activities is essential and there's a necessity to ensure water for the next irrigation season, not otherwise. They are always ready to do conservation activities provided they will get water for the next irrigation season. So that's a short-term requirement, a short-term goal. It's not sufficient to address the climate change. When we focus on conservation activities, we always, right now, the current trend is focusing on the supply sustainability, not on the source sustainability. We should devote some attention in law as well as policy, as well as at the local management to ensure that water is conserved for the purpose of ecological reserve. Unless the law addresses that in detail, as well as the perception of people about water as a commodity in that sense, because that's only for the human needs, changes, I'm afraid we cannot address properly the climate change impacts, at least from India. That's my take on this.
Yeah, thank you for that, Gayathri. Gabriel, what happens at the international level? Are we going to have another factor for destabilization of international relationships on this regard, or do you think it's going to be business as usual?
Well, I'm more optimistic that this will be addressed at the domestic level than international level. Water and especially groundwater, as Stefano mentioned, being a strategic resource, and it is not just a strategic resource, but a security resource. And now we get into the realm of what does water security mean? And in many regions, whether it's South Asia or Middle East, other parts of the world, water security has a national security component to it, and it's problematic. And so I am not optimistic that climate change vis-a-vis groundwater will be addressed at the international level. It's more likely to be addressed on the individual domestic, which may not be adequate.
Okay, thank you for that. And well, your presentations were revolving around the local problems that you're facing, case of South Africa, India. Well, Stefano told us about a whole picture around the world, and Gabriel as well. And usually the discussion is that public policy is not advancing as we academics want for this to go. And the role of the courts in this in the correction of this on these issues. How do you see or the impact in your countries, the role of the court, the role of the Green Tribunal in India, or the Supreme Court in South Africa? So they have introduced some kind of corrections into the system. So for all of you, do you see do you expect to move further along the courts in terms of advancing or recognizing rights for people in terms of access to water and sanitation, for example, Stefano?
Well, not only access to water and sanitation, but how do I say, respect for water, as a natural resource in its quality, and quantitative aspects. So now the role of the courts, yeah, sure. That there is this, the role of the courts is, it's quite, there is no denying, their importance, but essentially the courts are there to apply the law. Now, in certain systems, they are there also to advance the law, and maybe also to anticipate or to, to instigate the parliament, the lawmakers to take action. So in that respect, they may have quite a forward-looking, proactive approach. There is such a wide diversity of cases and examples that I defer to the, to my other to fellow presenters. But there's one instrument that you, Michael, are quite aware also of. It's this Brazilian Declaration of Judges on water, so-called quote-unquote water justice, which is not distributive justice, but it's just the function of judges, as you were alluding to protect and advance the cause of freshwater conservation, protection, and wise use, if you like. And there you have a distillation of how would I say, good practices maybe, or principles that the judges, the judiciary, may take up and follow in administering justice in the field of freshwater resources. This was adopted in 2018. This instrument, the Brazilian Declaration, was adopted in 2018 at the World Water Forum in Brasilia at the time. But for more, I will rather leave the floor to more informed comments from fellow presenters.
Oh, thank you for that, Stefano. Thank you. Barbara, do you have any views on this? What is happening in South Africa?
Yes, South Africa has very clear views on that. That's why the National Water Act has been replicated, etc. And also learning about it. I think it is vital that some issues are tried to be solved at national level with all people involved. Because otherwise we know who is going to have the security of water. It's again the wealthier, and it's not the poor rural. So the law is definitely, hopefully, also strengthening civil society in invoking the law. The human rights are, I think, very important. One thing though, we have to educate the judges. A judge who can say that water goes to waste if it isn't used by a very high impact economic user, he doesn't understand water, unfortunately. But for the rest, definitely.
Oh, okay, thank you for that. Gayathri?
Coming on to the role of courts from Indian perspective, I could say it's the courts which has strengthened the evolution of water jurisprudence in the country, especially, in general, as well as the groundwater protection also. For instance, when we say water is a fundamental right, the human right recognized as a fundamental right under the Constitution provision of right to life, it's a court that has spearheaded the rights based jurisprudence for water in the country, because we don't have a statute or an executive framework that ensures the right to water for people. They always follow this welfare-based policy. So the courts have asserted the right-based approach in water in general. And coming on to the groundwater situation, even though we follow this land-water nexus in regulation, but the courts have tried to address the groundwater pollution through different cases, public interest litigations like MC Mehta cases, because it's through one of the case that the court has ordered or directed the central government to constitute a groundwater authority to control the groundwater exploitation in the country. So it's through it directed the central government to execute the power under the framework legislation of Environmental Protection Act to ensure groundwater situation and reduce the exploitation. So we have the specialized tribunal called the the National Green Tribunal that also focuses on different cases relating to groundwater pollution. So I think if we trace the history of or the trajectory of groundwater jurisprudence, it's the court that have strengthened rather than the legislature, the executive. So courts have a strong role. And just adding one point to what Stefano said about the Brasilia Declaration, we can see almost all the elements of Brasilia Declaration on water justice being imbibed in different judgments of the Supreme Court as well as various high courts in the country. So we are following that principle. And one of the case of the Bombay High Court has specifically mentioned about the importance of Brasilia Declaration in India also. So I think the courts have definitely an important role in water jurisprudence, at least in India.
Fantastic, thank you. And Gabriel, probably, well, international courts are really slow than national courts, but do you have any expectations, for example, in the case of Nicaragua versus Costa Rica or something coming from that side, or do you think it's going to be business as usual at the international level?
Well, no international court has addressed groundwater per se, and I don't expect. I have to be careful because you never know what happens in between countries and international law, and there are some disputes over transboundary aquifers. But I just don't expect to see an international tribunal, the ICJ or another, to address a dispute over transboundary aquifers. We did just have a dispute resolved in the U.S. Between two U.S. states, the U.S. Supreme Court, and it's instructive because the U.S. is a federal system and has states, and this was a transboundary interstate aquifer, and the U.S. jurisprudence has actually has formed some of the basis for customary international law in the area of the law of international watercourses. So I think this U.S. Supreme Court case will be instructive, informative, but I think I would expect to see more cases in other jurisdictions, whether Brazil, in Europe and elsewhere, India, that it will come first before we see one before two countries in front of an international tribunal.
Okay, thank you for that. Well, let's hope that it's going to happen sooner rather than later. And I will give the last word to the speakers if you want to say something, or if not, so we are 5 minutes over our time. So we would like to give thanks to all the presenters. It was a wonderful webinar. So having you on the floor, it was spectacular. People that have a lot of experience on this regard. So it was really a marvelous opportunity. And thank you for all the people that are with us at the moment, and a big hug to the people who are going to watch this video on the different channels that we are using at WCEL. So in the name of the World Commission of Environmental Law, and particularly the specialist group on water and wetlands group from WCEL, thank you very much, and well, a big hug to everyone, and hope to see you soon. Okay. Take care and thank you.
Bye, everyone.
Thanks.
Bye, Stefano, Gabriel,
Bye.
Gabriel.
Bye.
Bye, thank you.